Hi, I'm Russ Bleemer. I'm the editor of Alternatives to the High Cost of Litigation at the CPR Institute. That's at www.cpradr.org. And Alternatives is published by John Wiley and Sons, Josie Bass Unit in San Francisco. And full subscription information is at altnewsletter.com. You can follow us at altnewsletter on Twitter. I'm here on CPR's YouTube channel and delighted to have Heather Cameron from the Fordham University School of Law. Heather spent a big chunk of spring and summer with us at CPR as an intern and spent a big chunk of her time at CPR watching the U.S. Supreme Court's alternative dispute resolution work. Specifically, that would be the stream of arbitration work, arguably the busiest commercial business subject that the court tackles. Heather's been kind enough not only to do that, but she undertook just an omnibus of an article on the court's doings, which is going to appear in the September issue of Alternatives. You'll find that at altnewsletter.com on around September 1st. In this article, Heather first looked at the GE Energy case. That was the sole Supreme Court arbitration matter decided and the term concluded this summer. That was after a year in which there were 3 arbitration cases decided. GE Energy is an international arbitration practice area matter. That's someplace the court doesn't visit too often. So just on that basis alone, it's a significant case. Next, Heather looked at in the article a peek ahead to the term that starts in October. That's a view of the Schein case. Schein was one of those 3 cases decided in the previous term, and now that same case is back on another similar arbitration point. Finally, in the article, Heather fills us in on a case the court rejected and tells us why maybe the court shouldn't have rejected the case and why its effects are a crucial practice point for arbitration advocates and arbitration neutrals especially. Heather, on the first one, what's the key takeaway? The case is, GE Energy is on the ability of non-signers to an arbitration contract to be able to use the contract to compel arbitration. What's your view on GE Energy and what do we have to know about it?
Thank you, Russ. So the big takeaway from GE Energy was that there's nothing in the New York Convention that prevents the application of state law doctrines like equitable estoppel from applying in cases where there was an international arbitration contract. So doctrines like equitable estoppel that are state law doctrines have been used to compel arbitration between non-parties to the agreement in the past, and this case just confirms that those doctrines are also potentially applicable to international contracts. So the article takes a look at that. It boils down what Justice Thomas's opinion and Justice Sotomayor's concurrence mean for practice, but it also takes a big look at what this means for both of the parties involved in this specific case, including a big look at the cost of arbitration and choice of law questions. So on remand, the circuit court is going to have to make some difficult choice of law questions, doing some balancing tests that are talked about in the case or in the article. And the arbitration, if compelled, is going to be with the ICC. So I took a look at what that would cost and why that may have been a factor in Outokumpo's desire not to go to arbitration on the case.
Practitioners are really going to appreciate the view. I mean, the case itself is arcane. It deals with state law doctrines of equitable estoppel and how that applies to a well-known international treaty on the enforcement of arbitration agreements. That's the New York Convention. But Heather's taken it another step for practitioners and talked about the implications of what it costs to go to arbitration and how that figures in this case, even though it wasn't a part of the case. So we really, really appreciate that insight, and I think people are going to enjoy that when they see the article. Now, Heather, why is the Schein case back at the Supreme Court? We've been following that for a long time. There was a buildup, there was a decision, it was over, and now it's here again. What do we have to look forward to in the fall in this repeat of the last one?
So this is just a new, very small, narrow question in 8 years of litigation that has been in the Schein case. So last year, the decision by Justice Kavanaugh eliminated the Oh, if you can help me fill it in, my brain is blanking on.
Well, it was to talk about a small point. They did away with the wholly groundless basis of refusing to compel arbitration. In other words, the court did not compel arbitration because they thought that the basis of the arbitration was wholly groundless, and the court said that's not a thing.
Yeah, so the question before the court this time is whether a delegation agreement is negated by a carve-out provision in the contract. So it's just another small step forward in whether arbitration is going to happen at all. So the article talks a bit about that, and then goes into a bit of detail about the question that was raised on cross petition that the court did not grant cert on, and that dealt with the clear and unmistakable standard for delegation agreements incorporated by reference. And this is potentially an issue that the court may avoid addressing altogether, but is actually maybe a more interesting and far-reaching question that could be brought up maybe in dicta around the case, but I talk a bit in the article about what that means.
Yeah, wholly groundless point is a tiny part of arbitration, which was great for the court. They can get a basically unanimous decision on that. And now they have another very small point on the delegation agreements. To be clear, the day the court in June took Schein and agreed to hear it again, they rejected that same day a cross petition on that potentially more interesting issue, deeper issue, and certainly a broader issue than either of the two that they have, one ruled on and one is about to rule on.
So hopefully the takeaway of the article is just shedding a little light on those issues and then giving practitioners an idea of how to avoid getting themselves into the type of situation that has led to all of this back and forth Schein litigation in the first place.
Yeah, and perhaps as we had discussed earlier, it could mean a Schein 3 and 4 if something else comes up related to the delegation agreement. You know, you reminded me, I can throw in a plug. I've got a great article coming up later this fall in Alternatives from a professor at Temple who talks about how corporations use those carve-out provisions and use them to their advantage in arbitration. And sometimes they think they're using them to their advantage, but it comes out to their disadvantage. It's kind of an interesting take. And I'm looking forward to following your article up on that, and also following subsequent Schein coverage up on that. Finally, Heather, the court, in looking at all of the things the court did this summer, the court declined to hear the Monster Energy case. That's a Ninth Circuit case that overturned an arbitration award, which is a pretty rare thing. And it did it because the arbitrator didn't disclose that his firm had a long relationship with one of the parties, and also he had an ownership interest in the arbitration provider, and therefore, by implication, has a vested interest in pleasing that party to continue the relationship. The Ninth Circuit decision didn't go that far, but it certainly found there was evident partiality under the Federal Arbitration Act and struck the award. So that stands, and it is what it is, without the court having revisited it. Why is it important, Heather, for practitioners? Why is it important for advocates, arbitrators to follow what happens with Monster Energy down the road very closely?
Yeah, so it may seem weird to talk about a case that the court decided not to take, but as we know, the court declines a lot more cases than it takes, so that doesn't necessarily mean that this isn't an important issue. And the fact that they've declined cert leaves standing a circuit split on some courts adopting a standard of evident partiality on the part of an arbitrator that is more akin to the judicial standard that requires that there's not even an appearance of bias, whereas other courts have used a standard where a reasonable person would be required to conclude that there was bias on the part of the arbitrator. So with that circuit split standing, the definition and requirements of evident partiality is still a little bit unclear, and that has implications for practitioners because different providers have different disclosure requirements, and it's unclear right now how much disclosure is required in order to protect an arbitral award from potential vacatur under the FAA.
Yeah, the standard is always disclose, disclose, disclosed. In this particular instance, there is no question that the arbitrator thought he had disclosed everything he needed to disclose. And the court itself, the Ninth Circuit, had said this should be easy because the standards that are required by the state they were in, which is California, are very high, and he just didn't meet those standards. So the provider at the time, JAM, said it was revising its disclosure requirements. It has since said it's doing that. Full disclosure here, the CPR Institute, which is publishing this video, has looked at its as well. I'm sure that the same can be said of every provider nationwide is going to be looking at this case, and we're already seeing some examples of it being cited popping up in local courts. So it's something we really want to watch closely. Did you have a prediction on the return of Monster Energy? You think it's going to come back to the court eventually? It's a 52-year-old case, Commonwealth Coatings in 1968, which last looked at evident partiality. You'd think maybe once or twice a century they could revisit it.
Yeah, I think based on the fact that the clause of the FAA that mentions evident partiality was written in the 1920s, and the court last addressed the standard in the 1960s. It's been a long time since the court has addressed it, and arbitration has changed a lot since then. So what may constitute bias or too many arbitrations between one particular party and one particular arbitral provider, it's just changed a lot in the intervening years. So I think even if this is it for Monster Energy itself, I think that it's likely that this specific issue will come back to the court eventually, maybe in a state court decision or some other tweaking of the facts. I think that this isn't the last that we're going to hear about the evident partiality standard. Agreed.
We'll both, and speak for the profession, we'll be watching as these cases come up, because they are certain to come up as time goes along. And I agree. I think it'll wind up back at the Supreme Court. And I don't think it's going to be 50 years. So. Heather, thanks so much for looking back at the court year and looking forward to the fall as to what's going to happen. We really appreciate it on behalf of everyone at CPR and our readers as well. Again, around September 1st at altnewsletter.com, on Lexis and Westlaw the day after as well. Please read the article. And Heather, thank you so much.
Thank you.